Assalamualaikum and greetings. My name is Nur Nadia binti Muhammad Khalid. Today I'll be representing about the topic of breach and trust. According to the presentation, there will be several topic outcomes, which will be introduction, the summary articles for trustees' liability for breach of trust and breach of fiduciary duties, and concept of tracing as a remedy for breach of trust under Malaysian law, research findings, legal provisions, and conclusions. For the introduction, the meaning of breach of trust is a failure to act responsibly for someone who has given you something to keep safe. The common allegations for breach of trust, such as distributing assets to a beneficiary not entitled to them under the trust deed. Second will be investing trust assets in a way not permitted. The third will be breach of fiduciary duty. And the fourth will be breach of the common law or statutory duty of care. For the first article, it will cover the Trustee Act of 1949, delineates the powers and the duties and responsibilities of trustees, providing the foundation upon which the liability of trustees is assessed. The first will be breach of fiduciary duty. Trustees owe a fiduciary duty to act in the best of interest for the beneficiaries. A breach of duty may occur if a trustee acts inconsistently with the terms of the trustee. The second will be negligence or mismanagement of any trust property, which is to manage trust assets prudently, or the actions are lack thereof, the results is negligence. The third will be conflict of interest. The conflict of interest is such as self-dealing with the entails, trustees gaining benefits from trust transactions involving trust property, whereas the personal interests diverge from the beneficiary's interests constitute a serious breach of trust. The fourth will be failure to distribute, and the trustees have an obligation to distribute trust assets in accordance with the terms of the trustee or testamentary trust. And the fifth will be unauthorized profits. Unauthorized profits, the trustees must not derive unauthorized profits from their positions. If a trustee personally benefits from the trust assets, such as making profits, therefore the trust property in a manner not permitted by the trustee and may be held liable for restitution and required to account for any unauthorized gains. The second article will cover the concept of tracing as a remedy for breach of trust. Tracing is the process of identifying a new asset as substitute for the old. For example, if money is used to purchase a car, the money can potentially to be traced into the car. And for the tracing in equity, if the claimant is able to establish property was transferred in a breach of fiduciary duty, they will be able to use equitable tracing. This allows the claimant to trace through mixed fund and to take the increase in value of any assets bought with the funds. However, this is also, it appears, available in common law tracing. Equity can also trace money through electronic fund transfers, whereas common law cannot. However, there are the requirements to trace the inequity, such as the claim must be based on a pre-existing fiduciary relationship. It is a prerequisite for an equitable tracing claim that the claimant had some equitable interest in the original property, or second, property must be in a traceable form, such as there must be some property to attach to, and it must be equitable to trace. Mixed fund in the concept of tracing, in other words, where the fiduciary trustee takes money from the trust fund and makes the money with their own money, which is equitable tracing operate in that circumstances. In other words, the court may choose if it is a trust investment or from trustee's own pocket. If investment is good, it will be trust investment. If bad, it will from own pocket. As for the research findings, a total of 53 cases of breach of trust involving an estimated value of 54.96 million ringgit detected from 2023 until May 2024. Notable cases of legal fees deception in which trustees self-dealing with the beneficiaries and also apart with banking institution which raising interest rate on the complainant's company loan. This has been recorded based on the reports and cases among lawyers. In Malaysia, the legal provisions for breach of trust are found in the Penal Code, specifically in Section 405 and 406, also 409. The first Section 405 defines criminal breach of trust as dishonesty, misappropriating, converting, using, or disposing of property that has been entrusted to someone. For Section 406 states that the punishment for criminal breach of trust is imprisonment for up to 10 years, whipping and a fine. And also Section 409 up to 20 years of imprisonment, specifically for public servants, bankers, and it includes whipping and a fine too. In Malaysia, criminal breach of trust is a serious crime that involves betraying someone's trust to steal or misuse their property or money. The penalties are included in the legal provision explained previously. And to be convicted for breach of trust, it must be entrusted with property or dominion over the property, dishonestly misappropriate or convert the property to their own use, dishonestly use or dispose of the property. The court may order the guilty person to recompense the victims of the offense and pay the cost of prosecution. The victim of a criminal breach of trust can also file a separate civil action to recover damage or property. That's all from me. Thank you.